Hey guys, I'm just making a quick video to go over the two main court cases about how Congress and apportionment work, Baker versus Carr and Shaw versus Reno. So the reason that they have you look at Baker versus Carr, even though it seems like a pretty straightforward decision as far as like, well, the courts decided they were allowed to look at certain types of cases, it's really important because the courts typically early on in their history tried to avoid what we call political questions. And you might be thinking, why would the courts want to avoid political questions? Isn't that what they're there to answer? Well, not really. The courts are there to answer constitutional questions. Questions about what the law means, questions about what the Constitution means, questions about the law's relationship to the Constitution. That's kind of what they're set up to do. Political questions are things like, should abortion be legal or not? Should one political party have more power than the other political party? Should this policy be enacted or should this policy not be enacted? And early on, the Supreme Court actively tried to avoid political questions because it would put them somewhere between the two political parties. And if the courts want to maintain their independence, they try to avoid looking like they're playing for one team or the other. So the issue in Baker versus Carr dealt with reapportionment, that every 10 years we have a census, and that census is designed to tell us how many seats each state is going to get in the House of Representatives. So it's a really important question for the political parties because they want to know if their party is going to gain seats or lose seats depending on what states grow and what states are not growing as fast. All the states are growing relative to each other. It's just some grow faster than others. You've probably heard like Ohio is shrinking because after the census we're likely to lose one more seat in the House of Representatives. Well, it's not that Ohio is shrinking. Ohio's just not growing as fast as Florida, Texas, Arizona, Colorado, the states that are going to gain seats most likely because people are flocking to them. Leaving Ohio is an Ohio tradition. It goes all the way back to the earliest Ohioans who kept on going and moved other places. Think about it. Neil Armstrong, first man to walk on the moon. That's the furthest an Ohioan has ever gone to get away from Ohio. So, the reason that Baker is a political question is because the courts typically said, hey, making congressional districts, drawing those boundaries, that's something that we're going to leave up to the state governments, and the state governments are going to be controlled by political parties. So in Baker's case, Tennessee had not redrawn their district lines since 1901, but the cities and the population centers of Tennessee had moved around since 1901. Some cities were growing, some cities were shrinking, rural areas were still pretty much rural areas, but the new map that Tennessee drew didn't reflect any of these changes. They basically looked at the results of the census, said, interesting, then ignored them, and used essentially the same map they had always been using. And that meant that some districts had lots of people in them, and some districts had virtually nobody in them. So the big issue in the case was whether or not the districts needed to be redrawn in a way that reflected that the population had changed, that people weren't living in the same place they were 10 years ago. And in Tennessee's case, this had been going on for decades, so they were using a map that was now multiple decades out of step with what the state actually looked like. The lower courts had said, hey, that's not typically a case that we would let the Supreme Court see because the Supreme Court doesn't like to look at political questions, and how the states are drawing their maps is an issue to be settled between the political parties within those states. It's not something that typically the Constitution has a lot to say with. So each side's goals, they vary, but Baker's goal was basically to stop the state from holding elections until a new map had been drawn, and the state of Tennessee, represented by Carr, wanted to say, hey, this isn't the Supreme Court's business. They can ignore this case like they have countless cases in the past about redistricting. This is mainly a 14th Amendment issue because it's about citizens being equally protected and equally represented, and because the districts were so out of whack. If you lived in a rural district, you had more of a say in who went to Congress than if you lived in an urban district because of how disproportionate the districts had been drawn. This also deals with Section 4 of Article 4 of the Constitution, which guarantees that states have a republican form of government, and that means that the states are built on representative democracy, that people have the ability to select and send representatives off to the National Congress. So they're saying that both the 14th Amendment and Article 4, Section 4 guarantee that to the people living in those states. This would primarily be a civil rights issue. It doesn't directly involve a civil liberties group. Typically, if the 14th Amendment comes into play, we're looking at a civil rights issue because the 14th Amendment is the bedrock of civil rights law. It's all about how the government relates to the different citizen groups within it. So this would primarily be a 14th Amendment case, and so it's primarily going to be looking at people's rights and how their rights are respected and upheld by the government. If you're asking the government to intervene and uphold something, odds are you're looking at a civil rights issue. As far as the majority opinion, the courts ruled that Baker's claim fell under 14th Amendment Equal Protection Clause. It didn't violate the questions that the court devised to decide if something was indeed a political issue, and so the court said that they could allow for the case to be reviewed. The dissenting judges argued that the case did not really violate any guaranteed clause, so it was not a judicial matter. But what's really important here is, again, it allowed the courts to review how the district-making process was being done, how states were redrawing their districts, at the bare minimum to ensure that the 14th Amendment's Equal Protection Clause was being upheld, and that the districts were, and this doesn't come out of Baker directly, there's another case called Westbury versus Sanders, that did then go on and say, hey, districts need to have their populations roughly approximate. So there's this principle that you read about called one person, one vote, and that means that roughly each person should have the weight of one vote ascribed to them. But if you live in a district with almost no people, your vote might actually count for more votes than someone who lives in a district that's really densely populated. So the Westbury versus Sanders took Baker versus Carr and said, hey, you got to get about the same number of people in each district. And the end result of that then is that you see, districts that have cities in them tend to physically be smaller because there are more people there, and districts that are more rural tend to be geographically larger because they're trying to get about the same number of people in each district. So that's the important part in Baker versus Carr, that they're trying to make it so that the courts now can review how these districts are created, and ensure at a bare minimum that you've got about the same number of people in them. As far as the next case, Shaw versus Reno, this one dealt with, it links to Baker versus Carr because without Baker versus Carr, the courts never would have reviewed a redistricting case. This one dealt with racial gerrymandering in North Carolina, and that the districts had very irregular shapes. That's usually a red flag for gerrymandering. If you look at a congressional district map and it can make a letter of the alphabet, odds are there's some serious gerrymandering going on there. In this case, the gerrymandering was being done to benefit minority citizens in North Carolina. Basically, they were trying to ensure that there was, at a minimum, one district in which minority members, in this case it would be black citizens, would have a majority within the district. And so it was created to ensure that at least one minority representative would be elected to Congress because people tend to elect people who look like them. The challenge here, though, was that race was really the only reason why that district looked that way. And so the lower courts rejected the argument, saying, look, this is what the Voting Rights Act says, that you should try to make diverse voting districts. The issue, though, was there was no other reason for that irregular shape to be created. So really the most important thing here is this case did rule that if you can only use race as the main reason for why a district looks the way it does and why the boundaries of the district were set, then that's equally as discriminatory as trying to draw districts to prevent minority groups from having representatives that look like them. So the Supreme Court took the position that using race as your only criteria is always going to be discriminatory, regardless of if the justification is that you're trying to elect minority representatives. You can still try to create districts that are more fairly representative, that allow minority voices and communities of minorities to have representatives that reflect their interests, but it can't be the only thing that resulted in the map that was created. So it's an interesting case because it takes the 14th Amendment and says, yes, you want to make sure that citizens are being equally represented, but if you are using only their race, then you are still using the law to single them out for some specific reason, and that might also disadvantage groups within that district as well, that aren't that primary group that was being targeted for specific legislation. So Reno versus Shaw is a result of Baker versus Carr in that, again, the courts are looking at how congressional districts are drawn, but it has an outcome that's kind of irregular in that you tend to think of civil rights laws siding with the minority group. And in this case, they're saying you can't pick one group over another for special privilege. Now, the one thing the courts have ruled pretty recently on is that when you're drawing your districts, it doesn't actually matter what political party people are a member of. So the Supreme Court has, as recently as last year, basically said that's a political question still. If a district is being drawn specifically to help Republicans or specifically to help Democrats, that's none of the Supreme Court's business. Even if you can statistically show that the district was drawn in a way to be purposely abusive of the data that was available, especially in the 21st century, there's lots of data on how people behave, how people vote, and where those people live, down to individual houses that are now at the hands of political parties to make perfect gerrymander maps. The Supreme Court says that's kind of up to the citizens and the states and Congress to deal with. That's not a solution that they're going to provide. If you have any other questions about Baker versus Carr or Shaw versus Reno, feel free to shoot me a message on Edgenuity or an email, and have a good day.